Hello everyone, my name is Tshepo. In our previous video, we discussed delictual damages. Today, in part 2 of the same topic, we will be discussing how to bring a claim for delictual damages before court for adjudication. The first step in bringing a claim of delictual damages before court is to issue summons. Summons are the formal court papers that initiate civil proceedings against another party. In your summons, you have to describe your claim in enough detail to allow the defendant to answer to the claim against him. In other words, you have to give the date on which the incident that gave rise to the claim occurred. You have to specify the place where the incident occurred. You have to specify or name the defendant. You also have to specify the quantum that you are claiming from the defendant. Once your summons are drafted, you will then submit the summons to court to be issued. That means the summons will be allocated a case number and registered in the court register. Once that is done, we say that the summons have been issued by the court. Then those issued summons will be delivered to the sheriff of the court with instructions to the sheriff of the court to serve those summons on the defendant. The sheriff of the court will then serve the summons on the defendant either at his residential address, which you will have specified in your summons, or at the defendant's workplace address. Service on the defendant may be effected in several ways. It may be effected by serving those summons personally on the defendant. It may be effected if the defendant is served at his workplace by being served on any person, perhaps at the reception area, even if service is done at the defendant's residential address. Service can be effected on any person older than 16 years old who is found at that address, provided that they confirm that they know the defendant. Another way to effect service is that the sheriff can affix a copy of the summons to the door or the gate of the defendant's residential address. Once the sheriff has done that, the sheriff will then generate a report that confirms that summons have been delivered to the defendant, they've been served on the defendant. The sheriff will specify the date on which the summons were served on the defendant, and the sheriff will furnish you as the plaintiff, as the person initiating the claim. The sheriff will provide you with a report which is called the sheriff's return of service. So that sheriff's return of service will inform you that the defendant was served, how the defendant was served, and when the defendant was served. Based on the date that the defendant was served, you can count 10 days from that date, in which period the defendant must then enter his or her intention to defend the civil claim against them. So the defendant will have 10 court days, in other words, excluding holidays, public holidays and weekends, 10 court days to enter their intention to defend the civil claim against them. If the defendant intends to defend the civil claim against them, then the defendant must formally enter an appearance to defend by filing a notice of intention to defend. So the defendant will then have to serve you as the plaintiff with the notice of intention to defend and then file same at court. Then the matter is then regarded as a defendant civil action before the court. After that, the parties will exchange what we call pleadings. I won't go into those because they become technical, but it's basically a series of court papers that are exchanged building up to the trial. Once that is done and the pleadings are closed, meaning all the necessary court papers have been exchanged between the parties, the matter will be trial ready, then the matter can go to trial. Part of the process building up to the trial is the discovery process, where each party must disclose to the other what evidence they will be using at trial. So this is a very important stage in the process, especially for you as the plaintiff, because the burden of proving the claim rests with the plaintiff, meaning the onus is on the plaintiff to prove their claim before court. So basically the defendant could just come to court and keep quiet. You will have the duty to start at trial. You will have the duty to discharge your burden of proof, meaning you must first make out a proper case that requires the defendant to answer. If you fail to make out a proper case, the defendant can choose not to answer because you have not made out a proper case. So you need to make sure that you gather all the evidence that you will need to prove your claim. For example, if it's a claim based on motor collision, you will need the accident report, which shows the full details of the collision, where the collision took place, the name of the street, sketches of the positions of the vehicles after the collision, the statements that were made immediately after the collision, the conditions of the road, the weather conditions on the date, etc. So you will need to discover the accident report, meaning place it before the court. You will also need to discover an assessor's report, for example, who assessed the vehicle after the collision and recorded the damages that were evident on the motor vehicle. You might need to discover quotations for the repairs to the vehicle, etc. So the discovery stage is important. After that, it will be the trial, and there witnesses may be called. If you were traveling with another person at the time of the collision, for example, you call such witnesses, and the court will hear both sides and make a decision. Like I said, the onus will be on you as the plaintiff to prove your case, and after that, it will be the defendant's case. Then you will try to discredit your case or come with counter versions. In a civil claim, the court will decide based on a balance of probabilities. In criminal court, the court decides based on the case having been proven beyond a reasonable doubt. But with a civil claim, when the court is faced with two mutually destructive versions, the court will accept the version that is more probable. So in a nutshell, that will be your trial. Once both parties have presented their case at trial, the court will adjourn to consider all the evidence that has been led during the trial, all the testimony that has been given during the trial, and the court will likely set a date for judgment to be given. If the court is satisfied with the case that you have presented as the plaintiff, meaning the court is satisfied that you proved the negligence of the defendant, and the court is also satisfied with your evidence and explanation as to the quantum that you are asking the court to order, then the court will find in your favor. The court will give judgment that confirms that the defendant must pay you a certain amount. Let's say your claim amount was 50,000 rands. The court will give an order that says that the defendant must pay you an amount of 50,000 rands. The the order will also state that that amount of 50,000 rand will accrue interest from the date of summons until date of final payment. Once you have that judgment, you can then enforce the judgment. The way to enforce the judgment is to issue a warrant of execution that the sheriff may go and attach assets belonging to the defendant in order to satisfy the judgment debt. So once the judgment is given, the defendant has the option either to pay this 50,000 rand. They may even approach you with an offer of how they will settle the 50,000 rand amount. If you accept it, they can pay it in installments and etc. But if that offer of paying in installments is not acceptable to you, you are within your rights to proceed with execution, where the assets of the defendant will be attached to satisfy the debt. There's often a misconception where people say, it's fine if they get judgment against me, I'll just offer 100 rand a month. That's not how it works. The plaintiff who has judgment in their favor, who is now called the execution creditor. Once judgment is given, the plaintiff will now be known as the execution creditor. The execution creditor has the right to reject your payment offer of 100 rand a month if it's ridiculously low. So as the execution creditor, you do have the right to reject a payment offer by the execution debtor if it is too low and if it will result in the execution debtor paying you for the next 50 years. If that is the case, you can then just proceed with the warrant of execution and have the sheriff attach the defendant's assets to satisfy the judgment debt. Once you have decided to proceed with the warrant of execution, you must first have that warrant of execution issued at court, meaning the court must stamp it to confirm that the details reflected on that warrant are correct. Once the court has issued the warrant of execution, you may deliver it to the sheriff. The sheriff will then attend to any address where the execution debtor's assets are kept. So it does not even have to be where the execution debtor resides. If you are aware that the execution debtor keeps certain assets at a certain address, you may direct the sheriff to attend at that address to attach assets of the execution debtor. If the sheriff finds enough assets to satisfy the debt, then the sheriff will provide you with a report of which assets have been attached. You will then have to instruct the sheriff to remove those assets and sell them in execution. Usually at that stage, the sheriff will require indemnity or security from you, wherein you indemnify the sheriff that should it later transpire that the sheriff was not supposed to attach those assets for any reason, for example, that the order should not have been granted against the execution debtor, or that the assets attached did not actually belong to the execution debtor, anything that may give rise to a claim against the sheriff, you will have to indemnify the sheriff from such a claim. Once you have signed that indemnity, the sheriff will proceed to remove and sell those assets. Then that's when the sheriff will have auctions to auction off property belonging to debtors. So in a nutshell, that is the process of claiming delictual damages against defendants. Don't forget to leave your comments or questions in the comment section. Also remember to like and subscribe. See you next time.